The Honourable Leanne Dalzell.
It was not particularly instructive in relation to as a response to the issue that my colleague has raised. Because, if we are going to, again, traverse the history of this matter, the original legislation was in fact dealt with by the Honourable Phil Goff when he was Minister of Justice, and that was the amendment to the Juries Act. And the amendment to the Juries Act did provide for addressing a discrimination that did exist in the law prior to 2000, and despite the fact that the National Party had been in government at the time that they passed the Human Rights Amendment, which said they could no longer discriminate on the basis of age. And in 1993, that law was passed, and the National Party did nothing around the fact that nobody could serve on a jury beyond the age of 65 years. And that was actually something that the Honourable Phil Goff, as the Minister rightly pointed out, commented in this matter more recently. He was the Minister that removed the discrimination that said persons aged 65 years and over were in fact qualified to serve on a jury, which they weren't able to up until that point. And if we were going to ask questions about what people said they were going to do and what they actually did, then maybe we could ask the National Party why they sat on legislation for 6 years after it was passed and did nothing about overt discrimination on serving on juries. At age 65, when National was last in government, you couldn't serve on a jury at all, despite the fact that they were perfectly happy to take credit for the Human Rights Amendment, which saw discrimination based on age removed from our statute books. We thought pretty well thereafter, but actually many years after, because in fact the government actually had to keep extending the period beyond which the government was not capable of being challenged for having discrimination in its laws over and over again. I think there were 2 amendments that extended the sunset provision that was written into the original Human Rights Act. I have actually been here long enough to remember its passage through the House, and I know that the Honourable Member on the other side of the House does too, but for slightly different reasons than probably I do. But the point that I want to make is this, and that is that the Minister went on about how we hadn't previously considered whether this matter should have been addressed by the Select Committee. And as I quoted from the Select Committee report, we raised it in the Select Committee. We didn't think that it was sufficient to warrant moving an amendment in this House. But since then, a new Member of Parliament from a party that wasn't represented in the last Parliament has moved a supplementary order paper, which has caused us to reflect on the issue. And it isn't a question of whether we took a particular stance on a particular issue in a particular year in a particular Parliament. It's actually a question of whether the grounds are made out for sustaining a particular position we may have adopted in the past. Sometimes it's okay to say we've reflected on new evidence, we've decided that on the balance of what we've heard, we're prepared to consider that maybe there is another option. And I think that's what, to be fair, I actually think that Dennis O'Rourke, it's all very well to say that it's being inconsistent. I wasn't aware that this had been put up as a serious issue until I was involved in this particular debate and until I knew that one of my colleagues had moved an amendment. Now, I hadn't even contemplated whether our side of the House should be moving such an amendment, but I've heard him make a case for removing the discrimination that exists in the legislation. Now, let me just quote from the Cabinet paper that I referred to before, because I think it answers the question that the Minister raised. Giving registrars the power to grant permanent excusals in certain circumstances would provide a solution to this problem. Because it is important to retain a wide jury pool from which jurors can be drawn, it is recommended that the permanent excusal power be confined to the grounds of age and permanent disability or health problems, Mr Chairman.
Honourable Leanne Dalzell.
Other matters, such as religious objections to jury service, may change over time and the person may become available to serve in the future. Now, doesn't that actually really address the issue that the Green Party has raised? The Green Party said, what is it? What happens if somebody who has asked for permanent excusal suddenly wakes up one day and thinks, gosh, I wish I hadn't done that. I'm actually perfectly willing to serve on a jury. I don't want to have a permanent excusal anymore. I think I'll just write back in and ask for them to overturn it. That's why the Minister has written the significant amendment to the bill as introduced that she has done. She's taken on board the comments that my colleague David Clendon had raised in the second reading debate, as I understand it. Now, he raised a very good point, but what he may not have realised is that actually the government looked at this issue and felt that that issue was best addressed by not allowing permanent excusal. And I think that that is right. I think that if somebody has a reason for permanent excusal, then they should put the reason for permanent excusal, not simply to say I'm of a particular age. I don't know about other people in this House, but 65 doesn't seem as old to me now as it used to. And I think that there are many people who, yes, I get closer to it every single day. But it's exactly the same rate. We all feel the same way. But the point that I'm making is this, is that just because that is the way that the legislation has been drafted doesn't actually mean that we've dealt with the fundamental underlying problem. And that is that the government decided that there were a number of people who applied for permanent excusal. A significant number of those did so on the basis of age, but that was on the basis that they could apply each individual time on the basis of age. Why should age of itself be the reason for excusal? I have no problems with people saying, I'm applying for excusal on this case, but for these reasons, I want to be permanently excused from ever having to serve on a jury. I've got no problems with that. What I object to is that the starting point and the end point is the age. That just because I'm of a particular age, I have a right to apply for a permanent excusal. And it's almost sounding as if people believe that this is something that we should be able to give people in their twilight of their lives, that somehow at age 65 you can be exempt from serving on juries, as if that is somehow onerous, when we all know that in fact we rely on people committing to what is a civic duty to perform their jury service. And I know that there are people, because of their occupations, who have automatic exemptions, but often those exemptions are either based on the urgency of their location within the community, the doctors, the dentists, those that are required to serve the community in other ways, but they are also people who, because of their particular circumstances, would never be chosen to serve in a jury anyway. A member of Parliament, a lawyer, for example, would never be chosen to serve on a jury, and the same with the police officer. There is a conflict that sits with certain professions. But to say that that sits with somebody simply because they've reached a magic age doesn't actually make sense. And I'm not ashamed ever to stand in this Parliament and say that I didn't consider this issue when the bill was originally introduced, and I didn't consider the issue when it had its second reading. But I want to thank Dennis O'Rourke for having the courage to bring an issue to the floor of this chamber and to have it debated intelligently and reasonably, which I believe members have done on both sides of the House. There's an element of disagreement, but that's okay. But I think that it would be much better if Parliament itself could say, well, actually, maybe this isn't the position that we should have adopted. Maybe we've heard the argument, and maybe it's time to reflect on why we made the original decision and why we should make a change now.
The Honourable John Banks.
Mr. Chairman, I've been listening to this debate